Welcome back. I'm back again with Christina Carollo and Christina O'Shea, my partners, and we're going to be talking about depositions. Now, I know Christina O'Shea, you said that EUOs were your favorite thing to do. So, is it safe to assume that depositions are your second favorite thing to do?
If I'm being truthful, I think depositions are my first favorite thing to do.
Oh, don't tell anybody on the EUO side about that. So section two, the deposition. The deposition is a statement under oath by a party or a non-witness. We'll go through some of the goals of the deposition, the roles of the attorneys and the adjusters. The deposition is often where we can win the case if it's done properly. Usually 6 to 9 months from filing the RJI and the initial discovery and the PC date. That's a guesstimate. It can be shorter, usually not. It can be much longer in certain cases. So we'll talk about scheduling procedures and how we go about scheduling those depositions and then some of the common pitfalls that we see. So the deposition goals. Christine, what's your main goal on a deposition?
We're both Christinas, so you confuse me when you ask, but I will tell you what my main goal is when I'm doing a deposition.
I don't know if I should be professional or funny about it, but really my main goal is to trip them up, honestly. My main goal is you mean what is our main goal, like what we want to get out of the deposition itself?
Yeah, what's your main goal? What do we go in deposition? What are the goals? I mean, preparing for the trial, locking the events, comparative fault.
Well, yeah, I mean, if you're on the defense side, you want to be able to establish that they did, in fact, sustain an injury. You would love to illustrate that something was pre-existing or not causally related to the accident. It would be lovely to show that if they were an operator of a vehicle or operator vehicle, that they weren't looking in the intersection or paying attention or, things like that.
Yeah, there's a series. By the time we get to the deposition, we will have an initial theory of the case. You might hear that a theory of the case is basically where we're going, what our general defense is, or if it, let's, for argument's sake, it's a rear end, our vehicle rear-ended the plaintiff. Obviously, liability is going to be a problem, but maybe there's an issue as to injuries. Maybe there was a pre-existing injury. Maybe there's a lack of causation, things of this nature. There might be liability defenses where there's a side swipe, or there was a three-car pileup and our vehicle was in the middle. When we do these depositions, similar to an EUO, we do go through all of the background questions, asking them about what they were doing that day, about their conduct, about their lifestyles, which is important because if someone went to the gym every day and now they can't go to the gym every day, that's going to contribute to their damages. We also talk about prior damages or conditions or post damages, meaning post injuries, pre-accident injuries. Often people will have had multiple accidents. We go through each one, get the details of each one they're treating and the injuries that they sustained to see if they're the same here and also to see if they exacerbated any injuries, meaning making them worse. If at the deposition, it's the first time that we learn that this person had a prior accident or possibly even a post accident, another accident after the fact. Then we will go through post deposition discovery, which is in the next stage of our discussion. Medical treatment and provider details we go through in detail. Again, we're not doctors, but we are, because of the nature of our practice, knowledgeable about the anatomy and about the injuries and about the treatment. So if someone says they have a herniated disc in their cervical spine, we know what symptoms to ask for. How does it hurt? How can you move your neck? Is there radiating pain? These are questions that we ask to try and ensure that we identify their symptoms to the injury that's being complained of.
I think one of our main goals, all three of us, could probably agree, is that based on our thorough prep, we just want to make sure that the testimony that's given to us at the time of the deposition lines up with every inch of what we've discovered thus far in our prep, right? So that's from how the accident happened or where it took place or when it took place, what vehicle they were in, down to right statements they may have made at the scene, or what they reported to the ER doctors and nurses upon arrival at the ED if they went there. Like every little inch, we just, at least for myself, strategy wise, I want to make sure that what they're saying does line up to what I already know to be the facts. Right?
Absolutely.
I'm confirming what I already know. Oftentimes we have to pivot because they'll say something that's completely different than what we have in front of us at the moment. So you have to be able to do that also.
Yeah, we
That's
want
very
to
important.
go ahead.
Mike. I noticed that we're just discussing plaintiff's depositions. I think it's just as important when a co-defendant is being deposed that we don't lead those deposition. That's plaintiff's leading, but we need to pay super careful to what the plaintiffs are asking because we want to find some type of comparative negligence. And sometimes there could be a plaintiff attorney that's just not asking the right questions, you know? So you really need to pay attention and prepare your follow-up questions when it comes to that. So I see some defense counsels when it's time to do a co-defendant, they kind of like, you know, don't pay attention
Yeah.
and sit on the sideline. But I think it's very important that you pay attention to a
And
co-defendant's position.
especially too when our client is being deposed, because the deposition will be of the plaintiff and the defendant, and sometimes witnesses, non-parties can be deposed as well. You know, keeping an eye on our witness and prepping them, and by our prep meaning my prep, and I know you guys are very similar with a witness. I will just tell them to tell the truth.
Mm.
Just say what happened, tell the truth. If you don't know an answer, say you don't know, don't guess. I mean, it's
Yeah.
pretty
Answer
that.
the question that's being posed. So don't give them ultra details and extra information because we all know that attorneys love to hear themselves speak and they'll follow up with five more questions.
Yes,
Right.
agreed.
And it's funny because I always tell, like, if we're prepping a witness, I always say if it's a yes or no question, all you're giving is a yes or no answer. They're
Right.
going to, the other side is trying to come off, if they're smart, as your friend, and they're not. They're trying to put
Right.
this all on you. So don't give them any more information than they have asked for. And I give this silly example. I know it sounds really silly, but sometimes I'll say, sir, do you like pizza? I tell my clients like that's either a yes or no, not like, well, yeah, I prefer cheese pie, but sometimes I like pepperoni. And I said no, right? So they start laughing.
Right.
Like, now do you understand? And that's what it is. You want to make them work for it, obviously, on the other side. And Christine, your point is excellent. Most co-defendants, at the time of, well, does any other counsel have follow-up? Almost all of the time, they're saying, no, I'm good, I'm okay. But plaintiffs have a tendency to sometimes ask dead-end questions.
Yeah.
You always want to have this lens, like looking through the lens of how does this make our client look at like at fault, or how can we, rehabilitate that answer.
Yeah.
So I think it's obviously very important to pay attention during depositions, even when you're not questioning.
And thank you for putting pizza in my brain. I'm actually physically located in Brooklyn, New York right now. And the best pizza when I went to Brooklyn Law School, on the opening day, the keynote speaker said, "You're in Brooklyn, the pizza capital of the world."
Yeah. And anytime I travel outside of New York, I realize what a pizza snob I am.
Yeah.
My nose up at it all.
Difference, yes.
So everybody has a role in the deposition. The court reporter has a role, the attorneys have a role, and the adjuster has a role. For the adjuster, it's important for the adjuster. They want to provide us with everything they have, their SIU, their internal logs, make sure we're prepared. They share any prior claims history, accident reports, any kind of background searches that get done. They want to share with us, and so that we go in prepared. You can, as an adjuster, submit suggested questions. Why not? Your experience, you're in the industry, you know what the question, you know what you're looking for in the defense of your case. So speak to your attorneys. And if you don't be shy to ask, say, hey, make sure you ask these questions or get this information for us. We like to prep over the phone with adjusters. We just find it easier to have that communication, that open dialogue, and look at the file together, and then, of course, follow that up with an email. And make sure, as an adjuster, that your attorneys give you timely reporting because you need to know these things. Again, speed and being on top of it is important. So make sure that your counsel is getting you timely reports, that you get your transcripts in time.
Mm.
Any other roles you have for the adjuster? I mean, it's basically communicate with your attorney in a nutshell. We speak and we get on the phone.
Yeah, I mean, I think that that's crucial to actually have that conversation with an adjuster over the phone, even if you're doing it as like a roundtable effort. Sometimes Mike and I will get on the phone with the adjuster and do a three-way call. It just becomes a more real interaction. It's a little bit more raw than
Yeah,
sending out just a formal email, and
absolutely.
really understand exactly what they want us to go for.
Mhm.
We bounce ideas off of each other. And just like you said, just so that we're all on the same page. I think even in the middle of a deposition, there's nothing wrong with that. And we've done that a few times, or,
Yeah,
countless
absolutely.
times, really, where we get on and before we finish the deposition, we make sure that we covered every base at sometimes we give the adjuster a call and we say, okay, this is what we covered. We think we're solid. And the
Yeah,
adjuster says, well, can you just ask this or can you
right.
just follow up with that? And I think that's important. There's no reason why we shouldn't touch base with the adjuster in the middle.
Yeah, because we're a team, and when you're conducting a deposition, sometimes they could be long and grueling, depending if there's other attorneys who are asking questions, and the adjuster can look at it from an outside perspective and give you some insight into something that we may have missed that once we talk it through, even during right in the middle of the deposition.
Right.
Scheduling and procedures. Scheduling and procedure. I've mentioned city parts because if you're in a city part, one of the parties happens to be a city agency or a bus or something along those lines. You go into a city part in court, and that's pretty much the city does whatever they want to do whenever they want to do it. So we just have to kind of ride along and hopefully we get
And it
scheduled.
takes forever.
Yeah, if
Right.
we
Right
tried to
along and hope for the best.
Yeah, if we tried to schedule a deposition with the city right now, what's this, July? We'd probably be
You're
looking
looking at
maybe,
26 possibly.
yeah, like
2026 we're in.
I
December,
was going to say,
January.
yeah, lucky the end of the year.
Yeah, lucky the end of the year, and the courts give them the time. So what happens? Let's schedule the plaintiff's deposition. We have to coordinate, and this is often done by our support staff. I mean, we get involved picking dates and things of nature, but actually setting it up can and usually is done by support staff. And what they will do is they will contact the other attorney and pick a date. And then we, as the attorneys, we contact our witness, we make sure that they're available, and we give them the dates. We contact the court reporter, let them know the date and schedule that time and date. We get interpreters if they're needed, and we schedule them as well. Most of the time now, they're being done via Zoom links. We have had a couple of instances where attorneys have insisted on being in person, and the court said, well, if they're insisting on it, then we show up in person. We do like to show up in person sometimes and may insist on it if it's a particular type of case because we through the Zoom, we kind of lose a little bit of our questioning edge. It's a little bit more difficult to read body language and eye movements and things of that nature. The silent pause isn't such a great effective tool on Zoom as it is in person, things of that nature, like asking a question. You didn't mention that hurt your left arm, you hurt your right arm, and then waiting for them to respond and get all fidgety. So most of them are done during Zoom. The med review becomes important during this point because once we schedule and we set this thing up, we want to go over our med review again to make sure that we know exactly what type of treatments and things of that nature that we're asking for. But to set this thing up, that's generally the process, a lot of coordinating, and it's usually done via email with everybody agreeing. Oftentimes, there will be a chain. Christina, would you say a chain of 20 to 25 emails is not out of the question if there's three parties?
Easy.
Just on
Easy.
deposition, just to schedule them.
Yeah. And that's why you have great paralegals and great
Yeah,
support staff help you out with
And
absolutely.
that.
the positive thing about Zoom is that people become more available and they don't get
That's
busted.
true.
Very
So
true.
we like it for that reason.
Yeah.
Very true.
We
It's
have,
easier to tell somebody, hey, can we do this at 2 o'clock on a Friday?
right.
Whereas if it was in person, people are so reluctant and understandably so. But yeah, Christina, that's a good point.
Yeah.
And we get witnesses appearing. I mean, I've had witnesses appear from their car at lunch.
And they're on this sitting on their stairway because
Yeah.
their house was noisy with their phone.
Yeah. So it
Yeah.
does get the job done, which is a good thing. Common pitfalls that we run into: late delays, late authorizations. We don't have the medical records yet. Everybody's pushing for depositions. An aggressive tone can sometimes backfire. When we're asking questions, it's pretty much the way that we're communicating right now. We try not to get aggressive because depending on how you question, again, deposition, we could talk about depositions in its own section for 2 hours, which we may want to do. But as
I
an over,
I do.
I know, I know you do. As an overview, we try to keep a professional tone. Even if the witness can get hostile, we calm them down and don't meet their aggression. Uh,
Sometimes if we tag team, we do good cop, bad cop.
yes, that's true. We do do
We do
them
we do
together.
rock, paper, scissors before to see who's gonna be good cop and good and bad cop.
Who's going to be the mean one? Yeah. I don't want to say, but you're usually the bad cop.
I'm the bad cop. No, that's true. I'll take it. It's okay. I'm the bad cop for sure.
And Christina Kroll, I know we were talking about the other day the over reliance on scripted questions. You were doing a deposition with a another party, and they're questioning our witness, our defendant, and the plaintiff was kind of new, and he was just going on about questions that just had absolutely nothing to do with the case, and he's just reading line by line, no matter what the answer was that the witness gave.
I had
He
the
wasn't even listening to the answer. I had this too. I don't know if you're talking about O'Shea, but I had the same issue
No, you,
happen.
Carollo, that's yes.
no, yeah, and see, and I had the same thing happen this past week. Same exact thing with the plaintiff's attorney.
Yeah,
And strategically, what we do is we just object, because that kind of slips them up, and then they'll stop and realize maybe I need to use my head a little bit and read the
yeah,
questions before I ask them.
yeah.
But yeah, when I see a new attorney, I cringe, but that's just a side note.
I try not
Because that
to.
means it's scripted.
I try.
I don't think the attorney that I was dealing with was new. I just think that, like I said earlier, not to knock anybody professionally, it's just that sometimes when you over rely on that script, you're going down one path. And so it doesn't really matter what the witness is saying when you should be going down different paths. They ask
Yeah,
these questions that become dead ends and move on to the next
hmm,
topic, which, they're losing a lot.
yeah,
Yeah.
absolutely. And claimants may act as their own experts. What we mean by that is a deposition technique is to establish with the witness a course of conduct that's agreeable, that's a proper way to do it, a non-negligent way, and then walk them into the fact that they didn't do that in this particular situation. So for instance, a plaintiff slowing down, going through a red light, you establish that a light is there for you to stop, right? And these aren't technically leading questions. However, we can ask the question and frame it in such a way as to get yes or no answers, such as, is it fair to say that you'll agree that we should be stopping at red lights? And the witness, of course, is going to say yes. It's a prudent driver for you to stop at a red light early enough to not move into the intersection. Is that fair to say? And they'll say yes. And you say, well, in this particular case, you were sticking out of the intersection. Isn't that true? Yes. So then it's fair to say that you did not comply with the standards that you know are acceptable. Is that accurate? And they will answer yes. So now they just gave themselves up, basically admitting that they knew what the right thing to do was, but they did the wrong thing anyway.
And what's beautiful is that even if they answered no, they're now contradicting what they said 2 questions ago about stopping at a red light.
Right.
Yep.
Well, deposition techniques, we could spend some time on that, not for the general overview, but deposition techniques are interesting on how to ask and how to frame questions, how to get witnesses to say yes throughout the entire deposition, and meanwhile they admitted fault and they never said anything but yes. So these are interesting.
How also to hold off on showing them your documents or your pictures or, your
Right.
reports and letting them answer first
Yeah.
and contradict what then you're going to show them.
Yeah. And being prepared. We over prepare. We've always over prepared.
There's no such thing.
There's no such thing, right? Because
Mhm.
we're not afraid of that because if we over prepare and I don't need to know certain information that I prepared for, I'm ready. We're ready to go. So being prepared is very important. We do see attorneys who show up to these things and they're going, "What file am I on?" And they're flipping through papers and oh, you could tell what kind of a day that's going to be.
Mhm.
Or sometimes they show up and they don't even know who they're representing.
Yeah,
That's even
that's
better.
true. So adjusters, get everything you can to your defense counsel. Have conversations with them. Don't be afraid to tell them to ask certain questions. If it's a particularly difficult one or challenging one, ask them to give you a call before they sign off. A lot of times, what I'll do at the end of a deposition, I'll say, okay, can you please give me a 10-minute break? I'm going to review my notes. I'll come back and finish. And I put a pause on it and give the adjuster a call. Or I'll give one of my partners a call and say, guys, I need a minute. Let me run through this and bounce this off. No, Christine O'Shea, you did that just the other day. You called me up and you were like, Mike, let's go through this. I'm about to conclude. What do you think? And we came up with actually a good strategy, and it proved to be effective that we wouldn't have otherwise known if we didn't bounce it off each other.
Mhm.
Right.
So
Yeah.
communication's key. Over,
Treating it like a team effort,
yeah,
right? I mean, it's
yeah.
that simple.
Oh, before we finish the procedures, we will, after the deposition is held, we get a transcript from the court reporter. That transcript then gets sent out to the attorney, and we ask them to review it, and their witness will have to review the transcript, sign an errata sheet to make any changes. If they don't send the signed transcript back to us, then we have to send a letter that is after 60 days. If they ignore us, it's deemed signed. So this way we can use it later in motion practice, which we'll get into in the next section. So for this section, depositions, thank you very much, and we'll see you in a minute in our next section.